Hello again, everyone, and welcome back to the only show that dares to expose the truth behind the headlines. Buckle up, because today we are diving headfirst into a shocking turn of events from the highest court in the land that appears to be a win for gun owners, but also uncovers a deeper, more insidious plot against our Second Amendment rights. We're talking about the Supreme Court's silent but powerful denial of a petition in a case involving a major gun manufacturer. A denial that has huge implications for frivolous lawsuits against companies like Glock. This isn't just about a legal technicality, folks. This is about the constant assault on our constitutional freedoms, the never-ending attempts by anti-gun activists and complicit politicians to chip away at our rights, one lawsuit, one legislative workaround at a time. Today, we're going to break down how this ruling could be a lifeline for gun manufacturers, but also expose the blueprint these civilian disarmament states are using to try and dismantle our gun ownership piece by piece. Stay with me, because by the end of this broadcast, you'll see the full picture, and you'll understand why this is a fight we cannot afford to lose. All right, let's get right into it, because what just happened with the Supreme Court is a prime example of how the legal system works in mysterious ways, sometimes even in our favor. But we always have to read between the lines. We are talking about a case, Gustiffson versus Springfield, a petition that was sent to the United States Supreme Court, and guess what? That petition has been denied, and in this instance, that denial is actually a good thing. The ruling we're focused on was actually issued by the Pennsylvania State Supreme Court back on March 31st, 2025. Now, that date is critical, and it shows you how slowly these wheels of justice turn. This was the ruling that was being appealed to the United States Supreme Court, and by denying review, the Supreme Court has effectively left the Pennsylvania State Supreme Court's ruling in place. This is huge for gun manufacturers, especially a company like Glock. Now, we have talked about this before, the PLCAA, the Protection of Lawful Commerce in Arms Act. This act was designed supposedly to preclude any type of lawsuits against firearms manufacturers, especially when there has been superseding or intervening illegal activity. Think about it. If someone steals a car and hits someone, do you sue the car manufacturer? No. So why should gun manufacturers be any different? But here's the rub. And this is where the anti-gun lobby always tries to find their loopholes. There was a real question about whether or not the PLCAA only precluded common law tort claims, and whether states could carve out additional state statutes that could penetrate the protections of the PLCAA. We warned you about this back in November. We could see this tidal wave of new laws popping up, all being passed in a lot of these strict gun control jurisdictions, a polite way of saying states that want to take your guns. And these laws were clearly intended to be workarounds to the PLCAA. And then, you start matching that up with where all these ridiculous Glock lawsuits are dropping, and you realize, hey, this was a plan all along. This affects all the lawsuits against Glock that are based on illegal Glock Switches, these devices that illegally convert a semi-automatic handgun into a fully automatic one. This has nothing to do with potential SIG lawsuits, which are on a design defect claim, a whole different issue. But Gustiffson was absolutely dealing with an intervening illegal act, which is clearly the case in all of the Glock Switch cases. You have the illegal manufacture of the switch, the importation of the switch, the installation of the switch, and the use of the switch. That's at least 4 levels of illegal activity. The original case itself is a tragedy. A 13-year-old son, at home with a 14-year-old friend. They find a handgun, a Springfield handgun. It doesn't have a magazine, but tragically they're still around in the chamber. The 14-year-old pulls the trigger, strikes the Gustiffson son, and kills him. The 14-year-old is ultimately found guilty of involuntary manslaughter in juvenile court. The Gustiffson family sued Springfield and the FFL that sold the firearm, claiming that the firearm didn't have a magazine disconnect safety or a loaded chamber indicator. Everybody agreed that the claims themselves, under Pennsylvania law, were valid claims, meaning they could move forward, not necessarily that they were provable. The initial court dismissed the complaint against Springfield. Then, the Pennsylvania Superior Court found the PLCAA unconstitutional, arguing it violated the 10th Amendment by precluding state court claims. But then, on rehearing, it got all muddled. Now, the Pennsylvania State Supreme Court, in a ruling that is now final because the United States Supreme Court denied review, has found that the PLCAA is in fact constitutional. And here's the kicker. All of these claims, including all of the claims coming under state laws, are also precluded by the PLCAA. This is a massive win on the surface for gun manufacturers. But don't pop the champagne corks just yet, because the fight is far from over. Do you agree with the Supreme Court's decision to let this ruling stand? Let me know in the comments below. Here's the ugly truth they won't tell you in the mainstream media. This ruling, while seemingly a victory, highlights the relentless strategy of the anti-gun lobby. If they can't beat federal law, they'll try to undermine it with state-level workarounds. The Pennsylvania State Supreme Court had to resolve a central issue. Does the Protection of Lawful Commerce in Arms Act actually preclude all tort claims and any other claims being filed exclusively under state law? The applicable statute is 15 United States Code, Section 7902, Sub A. The plain language of that statute says, and I quote, "A qualified civil liability action may not be brought in any federal or state court." Now let's break that down. If you're bringing an action exclusively under state laws, the only place that action would take place is in a state court. So it would appear crystal clear that the drafters of the PLCAA contemplated precluding exactly these types of actions. This wasn't some oversight, it was intentional, and the Pennsylvania State Supreme Court ruled exactly that, saying, "Instantly, we find that the PLCAA contains such an express preemption clause, which explicitly preempts state law relative to qualified civil liability actions." They continued, "Thus, we do not apply any presumption against preemption, and instead focus on the PLCAA's plain language." Think about the power of that statement. They're saying, look, the law is clear. It says what it means. This is a court actually applying the law as written, a rarity in today's activist judiciary. So, standing alone, the Pennsylvania Supreme Court has found that these types of lawsuits, the exact same kind of lawsuits that are being brought against Glock right now, trying to blame the manufacturer for the criminal misuse of their product, are in fact completely precluded by the PLCAA. This is a direct blow to the blame the gunmaker playbook. But wait, there's more. Beyond simply precluding state law claims, the court also tackled the issue of intervening illegal activity, and this is crucial for the Glock Switch cases. The Pennsylvania Supreme Court found, "We find that the PLCAA's definition of qualified civil liability action as an action seeking damages resulting from the criminal or unlawful misuse of a qualified product by the person, or a third party, contains no such ambiguity." It clearly convinces Congress's intent to preempt a broader scope of actions than those suggested by plaintiffs. They pointed out that if Congress intended to limit the Act's bar only to actions solely caused by criminal misuse, it would have used that specific language, but it didn't. It used broader language for a reason. This means that if you have multiple layers of illegal activity, like in the Glock Switch cases, the illegal manufacture, importation, installation, and use, the PLCAA stands firm. This is a monumental ruling. Anyone defending Glock, or anyone watching these frivolous lawsuits against Glock, all based on illegal Glock switches, needs to get really familiar with this case. Gustiffson versus Springfield, Inc. This is a powerful moment for the Second Amendment, but it's not the end of the war. It's just a battle won, exposing the depth of the deception and the lengths to which these groups will go to disarm law-abiding citizens. Folks, this ruling by the United States Supreme Court's denial solidifies the Pennsylvania Supreme Court's decision, affirming the constitutionality of the PLCAA and its broad preemption of state-level lawsuits against firearm manufacturers. This is not just about Glock or Springfield. It's about the very foundation of how we protect our rights in a system designed to undermine them. The legal system is facing much controversy, but sometimes, just sometimes, the clear language of the law prevails, even when the Supreme Court simply chooses not to interfere with a good ruling. What this does is reinforce the idea that manufacturers cannot be held liable for the criminal and illegal actions of third parties. This is common sense, right? But common sense is a rare commodity in politics, and in many of our courts these days. However, let's not be naive. This doesn't mean the anti-gun forces are giving up. Oh no, not by a long shot. What this ruling does, by slamming the door on one type of workaround, is force them to find new ones. They will continue to seek new legislative avenues, new interpretations, and new legal theories to attack gun ownership. They will push for more restrictions on gun sales, more mandates on firearm design, and more red flag laws that strip citizens of their rights without due process. This is their playbook, and they never deviate. This ruling sends a clear message that the PLCAA has teeth, and that state attempts to chip away at it through cleverly worded statutes are likely to fail. But the battle is ongoing. Every time a new civilian disarmament law is proposed, every time a new lawsuit is filed, we have to be vigilant. We have to understand the nuances, the intentions behind the legislation, and how it impacts our lives, our families, and our fundamental rights. We're here to educate you, to inform you, and to empower you. Because part of being a lawful and responsible gun owner, as we always say here, is knowing what the law is in every situation and how it applies to you. This is a reminder that the fight for freedom is never truly over. It requires constant vigilance, unwavering commitment, and a deep understanding of the legal landscape. This isn't just about guns. It's about freedom. It's about protecting ourselves from a system that increasingly seeks to control every aspect of our lives. The Pennsylvania Supreme Court made a good decision, and the United States Supreme Court chose wisely by letting it stand. But we must remain hyper-aware of what comes next. Folks, the legal system is facing much controversy, but we are here to watch it, to dissect it, and to expose it. This decision is a temporary reprieve, but the war for our Second Amendment rights continues. What do you think about the Supreme Court's denial and its implications for future gun lawsuits? Do you believe this will deter anti-gun activists, or will it just push them to find new avenues of attack? Let me know in the comments below. Smash that like button if you want the truth. Share this video to spread the word, and make sure you subscribe to join the movement. Until next time, thank you for following today's legal analysis. Please leave your comments on this ruling in the comments section. See you again.